Indeed. OK, Joel, thank you very much indeed. Well, that was a big ruling there from the Supreme Court. Let's talk more about that now with lawyer Daniel Barnett. Good to see you there, Daniel. I mean, first of all, on the specific ruling itself, this is, I suppose, the first big high-profile ruling by the Supreme Court since it took over this judicial role from the House of Lords on the 1st of October. Is there any reason to believe it would have been different if the House of Lords had still been in charge of decisions like this?
No, none at all. The judges are exactly the same. They've simply moved buildings and walked a couple of hundred yards from the old House of Lords building into the new Supreme Court building in Guildhall. Same judges, it would have been the same decision. Yeah,
I mean, it is, though, more high profile because we see it there. It's, as you say, there in a specific, very, very grand building, but kind of in a more modern setting as we saw inside.
Yes, the Supreme Court, or the House of Lords, was modernised recently because there was a feeling that there should be a separation of powers between the executive, the House of Lords, and their law-making capacity, and the judiciary, which scrutinises those laws. And partly as a gesture and partly as something of real substance, the law lords were taken out of the legislative branch of government and put into a very separate judicial branch at the top of the court system.
And nobody really knows how this Supreme Court's going to evolve, because that political influence, if there was any in the House of Lords, or just been set there, it's gone away now. I mean, is there a situation, is there a scenario where people envisage the Supreme Court becoming bolder and at some point more willing to challenge the executive?
No, there's no power whatsoever, other than in very, very limited cases, for the Supreme Court to challenge the executive. But what one does see quite often is the Supreme Court making recommendations that Parliament might like to consider changing legislation. This case that we've just heard this morning is a classic example. Two of the judges, Lord Walker and Lord Mance, have actually called on Parliament to say, look, we've had to come to this decision because it's what the law is, but it is terribly unfair to people. Oh. Would Parliament consider changing the law?
Yeah, because it was quite narrow grounds there, as I was talking to Joel about. We heard there Lord Phillips saying this was not about if the charges are fair or not. They were not asked to rule on that.
That's absolutely right. They were just dealing with a very, very limited point, which is whether the Office of Fair Trading was allowed to even investigate the fairness of the bank's charges. The law says that where the Office of Fair Trading can get involved is pretty much any situation, except if it's to deal with the fairness of the price. And what the previous courts had said, what the High Court and the Court of Appeal had said, was that you have to look at the core part of the bargain, banking services, putting a bank account there and letting people put money in and take it out, and separate that out from ancillary services like unauthorised overdrafts, and the OFT was allowed to investigate ancillary services. What the House of Lords, the Supreme Court, has said is that that's not really a valid difference. The system of unauthorised overdraft charges is part and parcel of the money that consumers pay to the banks for providing banking services, and because it's part and parcel of that price, the Office of Fair Trading isn't allowed to investigate it.
I mean, because of those decisions in those lower courts, the High Court and the Appeal Court, a lot of people were expecting it to go the other way. I mean, when the House of Lords was in operation, presumably there have been quite a few cases where you've seen this happen, where the overall judgment has reversed the previous rulings.
Yes, it's not uncommon at all. Very often the House of Lords will depart from the way that it's decided cases before. The Court of Appeal is bound by its own existing decisions and bound by decisions of the Supreme Court above it. The Supreme Court can do what it wants. It can change the law in order to follow social conventions, in order to reflect changing moral values in society, whereas the Court of Appeal has to do what it's got to do because of previous decisions.
OK, well, thank you very much indeed. Fascinating stuff there. Thanks for talking us through it there, those charges themselves and the operation of the Supreme Court. Daniel Barnett there.